Welcome to Bracewell's webinar on the Pregnant Workers Fairness Act. I'm Amy Halevy, and I'm here with Caroline Thomas. Caroline is the newest associate in Bracewell's Labor and Employment Group. So we wanted to welcome Caroline to Bracewell. The Pregnant Workers Fairness Act, or the PWFA, went into effect in June of 2023. But even more recently, in April of this year, the EEOC issued its final rule to carry out the new law. The final rule just went into effect in June of this year. So really everything we're going to be talking about today is very new. The final rule, the document that the EEOC published, is over 400 pages long. If you are not inclined to read the full rule, it's good to know that the EEOC published a short document, and it's actually titled, What You Should Know About the Pregnant Workers Fairness Act. So after listening to this webinar, if you're looking for a short summary, which would be sort of a good reminder of the key points of the new law, that's a good place to start. And you can find it on the EEOC's website. Today, Caroline and I are going to be discussing some of the key aspects of the PWFA. And while you'll hear us talk about a number of similarities between the PWFA and the Americans with Disabilities Act, or the ADA, which, as you know, ADA is the other federal law that requires employers to reasonably accommodate an employee's medical condition. But even though there are lots of similarities between the two, we thought it would be helpful to really highlight some of the key differences between the two laws. We'll also be discussing some recent litigation. Now, I know I just said it just has not been around that long, but really in a relatively short period of time, the EEOC has been very active in filing cases against employers under this new law. And frankly, that's really the reason why we decided to do this webinar at this time, even though a lot of those lawsuits are still new and haven't really gone through the litigation process yet. So we don't really know the results, but it's still, I think, there are still lessons to be learned. In addition to helping you get more familiar with the PWFA, the goal today is really to review some of those cases, particularly those from the EEOC, and provide what we hope will be some helpful takeaways. Before we get into too much detail on the law itself, it's important to put this new law in context. The PWFA is intended to be a gap filler. What does that mean? It means it provides protections for pregnant workers where other federal laws like Title VII or the ADA, even the Pregnancy Discrimination Act, may not provide coverage. The PWFA has been more than a decade in the making. We have been talking about this for a while. It was first introduced in Congress in 2012, and it was reintroduced in almost every legislative session since then. Okay, let's break down some of the key points of the PWFA. As I suggested before, there are some similarities between the PWFA and the ADA. You'll recognize language and concepts in the PWFA that come from the ADA. But you need to be aware that there are some differences in how some of these terms are interpreted depending on the statute. Let's start with one of the most basic concepts. Like the ADA, the PWFA protects qualified employees and applicants. To be qualified, the employee must be able to perform the essential functions of the job with or without reasonable accommodation. Okay, so that definition should sound familiar. It comes from the ADA. And for many listening, you know that when you're analyzing an ADA issue, sometimes the issue of whether an employee is qualified is really an important one. There are times when, and again, after going through the interactive process with the employee, you conclude that an employee is not a qualified individual with a disability, and we're talking about under the ADA here, because they cannot perform one or more of the essential functions of the job, with or without reasonable accommodation. Let's go through an example under the ADA. Let's say you've got an employee, and the employee is a truck driver. In my hypothetical, the truck driver has a seizure disorder and is restricted from driving. Let's say also that the employee's doctor can't tell you when this truck driver is going to be able to drive in the near future. In this scenario, the employer may conclude that the employee is not a qualified individual with a disability because he can't perform an essential function of the job, driving, with or without a reasonable accommodation. And remember, under the ADA, you do not have to eliminate an essential function of the job. However, the PWFA analyzes the concept of a qualified individual a little differently. Under the PWFA, an employer or applicant can still be qualified even if they cannot perform an essential function of the job as a result of their condition. Okay, so you may be asking yourself, how does that even make sense? Same definition, different meaning? The answer is the EEOC expects employers to understand that a pregnant employee's inability to perform an essential function is usually temporary. The employee will likely be able to perform that essential function in the near future, and that really means within 40 weeks, the duration of a typical pregnancy. Therefore, the employee is supposed to excuse the employee's temporary inability to perform the essential function of the job, provided it doesn't create undue hardship. Let's go through an example. Let's say you've got a pregnant nurse who comes to Human Resources and asks to be excused from the requirement that she lift 25 pounds or more for the remainder of her pregnancy. Well, one of the essential functions of a nurse's job is to move patients to and from their beds, bathe the patients, dress them, and that obviously includes lifting more than 25 pounds. Even though the nurse is unable to perform an essential function of her job, she is still qualified under the PWFA, assuming she'll be able to perform the essential function of the job in the near future, so within 40 weeks, and that accommodating the medical restriction does not pose an undue hardship. And Caroline's going to go over undue hardship in a few minutes. In understanding the difference between the ADA and the PWFA, it's important to remember that the ADA definition of a disability includes employees who have a physical or mental impairment that substantially limits a major life activity. Contrary to the ADA, minor limitations may need to be accommodated under the PWFA. This is another way the PWFA is a gap filler. Examples of minor limitations include swelling, morning sickness, and a frequent need to use the restroom. It's important to remember that the law also covers potential or intended pregnancy. So it would include someone who's going through in vitro fertilization, for example. And that was actually an aspect of this law that got a lot of attention in the news. Like the ADA, in asking for an accommodation, the employee does not need to use any medical terms. There are no magic words an employee needs to say. But an interesting new concept of the PWFA is that the employee does not have to be the one to ask the employer for the accommodation. This is different than how the ADA functions, because in the ADA context, frankly, out of a concern for maintaining confidentiality of medical information, which is required under the ADA, the employer often refuses to talk to a friend or coworker or even a spouse of the employee about the employee's medical condition. But under the PWFA, the employee's representative can communicate the limitation, and a representative means a family member, a friend, union representative, healthcare provider, or any other representative of the employee. So how could this come up? Let's use an example. A pregnant employee's husband calls the employee's supervisor and says his wife just can't come to work today. She has severe morning sickness. This may be an excused absence from work, even though the employee didn't call herself, which may be required by the company's policy. So I think it's just an important thing to keep in mind when you're dealing with this on a day-to-day basis, that sometimes it could be somebody other than the employee who's giving you information about the limitation and what's needed. Caroline, why don't you talk a little bit about undue hardship, another familiar term?
Thanks, Amy. Like the ADA, the PWFA requires an employer to accommodate a covered employee unless to do so would be an undue hardship. And the PWFA follows the definition of undue hardship that's found in the ADA. Generally, it means significant difficulty or expense for the operation of the employer. The EEOC's guidance lists factors that may be considered in deciding whether an accommodation would be an undue hardship. These factors include the nature and cost of the accommodation, the overall financial resources of the facility involved, the overall financial resources of the employer, the type of operation or operations of the employer, and the impact of the accommodation on the operation of the facility. You may notice that these factors are the same as those considered to determine whether an accommodation would be an undue hardship under the ADA. But employers should note that, according to the EEOC, some requests will almost always be considered to not impose an undue hardship. These include additional restroom breaks or additional time to eat or drink. The duty to engage in the interactive process is another concept from the ADA. And like with the ADA, employers, and particularly human resources professionals, should document when they're engaging in the interactive process about an accommodation. The interactive process under the PWFA may be more pared down because the documentation is less involved. Amy will talk in a minute about documentation requirements under the PWFA. Employers should train managers to contact HR and document the interactive process, even when an employee is requesting a simple accommodation and the interactive process is very quick.
All right. As Caroline said, I'm going to talk a little bit about documentation because I think it is going to be something employers are going to keep an eye on or need to keep an eye on under the Pregnant Workers Fairness Act. Let's go back to the ADA. Under the ADA, employers are permitted to and arguably even encouraged in some situations to ask employees for medical documentation to support the need for the accommodation. But under the PWFA, documentation is going to play a much more limited role. EEOC guidance gives some examples of when it is not reasonable under the circumstances to ask for documentation, including when the employee's limitations are obvious, which frankly, for a pregnant employee, that's going to be the case most of the time, and the employee provides self-confirmation. Example, the employee goes to her supervisor and she says, look, I'm pregnant and I'm going to need to take a few more breaks during the day. Also, when the employer already has sufficient information, shouldn't ask for any more. And when the employee makes a simple, predictable request, for example, I want to be able to carry water or I need to stand or I need to sit or something that is predictable of a pregnant employee's needs. Another would be when the reasonable accommodation is related to pumping breast milk at work. All right. That's going to always be reasonable. But the amount of documentation, sort of what you can ask for, also needs to be limited. According to the EEOC, reasonable documentation is going to be the minimum documentation that is sufficient under the circumstances. Caroline, why don't you talk now a little bit about prohibited conduct under the PWFA?
The conduct that's prohibited under the PWFA is similar to the ADA, with a few exceptions. The PWFA actually spells out that an employer is prohibited from unnecessarily delaying providing a reasonable accommodation. And this is really important for employers to remember. Under the ADA, it may take an employer months to make an accommodation because it is gathering medical documentation and working through the logistics of providing the accommodation. But employers do not have the ability to delay making the accommodation under the PWFA. The following are factors used to determine whether a delay in providing an accommodation violates the PWFA. First, whether providing the accommodation was simple or complex. Second, whether the employer provided an interim accommodation that enables the employee to keep working as much as possible. And third, the length of time for which the employee will need the reasonable accommodation.
And I want to just sort of make another point on this. We're certainly not suggesting that under the ADA, employers should delay in providing an accommodation. Obviously, under the ADA, you still want to provide that accommodation in a timely fashion. But in the real world, when we're working through particularly some tricky situations under the ADA, there is often a lot of back and forth between the employee's doctor and the employee and talking to the manager and trying to figure out what the employer can do. And we just wanted to focus on this point in terms of the PWFA because under the PWFA, they actually list that as a prohibited conduct. So, where you can get into a situation where you have a violation. And therefore, it's just going to be important when a pregnant employee or employee comes and asks for an accommodation, there's going to be some urgency to that. All right. Now that we've reviewed key provisions of the PWFA, including some differences under the ADA, let's discuss what lessons employers can take away from recent lawsuits filed by the EEOC and employees. And we want to keep in mind here that the information we have right now, particularly from the EEOC's lawsuits, are really just from the complaint. So we're just hearing the EEOC's side of the story. So that's important to keep in mind. And we do have a couple of conciliation agreements, which Caroline's going to talk about as well. Within a few months of the EEOC implementing its final rule under the PWFA, the EEOC filed multiple lawsuits. Most of these lawsuits remain in the early stages of litigation, but still, we think it's really helpful to understand some of the situations where employers are getting sued, because the lawsuits brought by the EEOC in particular provide insight into how the EEOC is going to be enforcing the PWFA and how the EEOC, at least the current EEOC, interprets certain provisions. We're going to talk about 3 of the lawsuits filed by the EEOC.
The EEOC filed its first lawsuit under the PWFA in September 2024 against Wabash National Corporation. Now, in this case, the EEOC brought suit on behalf of an employee who assembled trucking equipment for Wabash, and her job required her to bend over the tops of trailers. 7 months into her pregnancy, the employee asked HR to move her to an assembly line position that would not place pressure on her stomach, to move to a light duty position, or to accommodate her in some other way. According to the EEOC's lawsuit, Wabash failed to engage in the interactive process with the employee. Instead, Wabash immediately placed her on unpaid leave and requested that her physician complete an ADA questionnaire. Not surprisingly, the employee returned the ADA questionnaire with her physician's notation that she had no ADA restrictions. The employee also clarified that her accommodation request was made under the PWFA, not the ADA. Nevertheless, Wabash allegedly refused to discuss the availability of accommodations, despite the fact that light duty was made available to non-pregnant employees, including those with temporary disabilities, who had requested accommodations in the past. The employee in this case resigned based on her belief that she could not continue in her assembly line position without risking the health of her pregnancy. The complaint alleges that Wabash violated the PWFA by failing to accommodate, forcing the employee to take leave, and interfering with the employee's exercise of her PWFA rights. What can employers take away from this case? Wabash illustrates the fact that under the PWFA, employers may not require a qualified employee to take leave, whether paid or unpaid, if another reasonable accommodation can be provided to the known limitations.
Thanks, Caroline. One other aspect of Wabash I think is important to keep in mind, because I think this is what's going to actually happen in a lot of situations, and that's that an employee comes and asks for an accommodation, and HR is so ingrained, appropriately so, with, here, let me go through my ADA process. So in this situation, that's what they did. They sent the ADA questionnaire, but the employee doesn't have a disability under the ADA. And that's why the doctor responded and said, no ADA disability here. But there was still a need for an accommodation under the PWFA. All right, let's talk about another case. In the Polaris case, the employee told the company she was pregnant when she attended new hire orientation. A little interesting, she didn't tell the employer when she was going through the hiring process, but she had no duty to do that. But she did tell them when she was going through new hire orientation that she was pregnant. And soon after she was hired, the employee needed to miss work to attend some pregnancy-related medical appointments. And she also needed time off for pregnancy-related conditions like nausea, swelling in her feet, those types of things. Unfortunately, she was not entitled to take time off under the company's policies. She hadn't worked there at least 60 days, so she was still under their probationary period. So the company started assessing attendance points against the employee and even warned her that she'd be terminated if she had another unexcused absence. Another issue that was facing this employee was that the assembly line that she was assigned to required employees to frequently work more than 40 hours a week to meet their production goals. And one of the things the EEOC points out in their complaint is that there were other assembly lines that didn't require as much overtime. When the employee notified the employer of her restrictions regarding overtime, the HR manager told her that overtime was an essential function of the job. And this is according to the EEOC's complaint. according to the EEOC's complaint, the HR manager said, well, her doctor could give her pregnancy restrictions, but the doctor didn't know the company's policies. Ultimately, the employee resigned because working overtime violated her medical restrictions from her physician, and because she realized she would be terminated the next time she needed to attend a medical appointment for her pregnancy, which was obviously going to come up. The EEOC sued Polaris for failure to accommodate known limitations related to pregnancy and constructive discharge. This lawsuit certainly illustrates the fact that under the PWFA, an employer should not automatically conclude that an employee is not qualified if the employee is unable to perform an essential function of the job. In this case, it was working overtime. In the complaint, the EEOC notes that to the extent the employee could not perform the essential function of her job, she was still a qualified employee under the PWFA because the inability to perform that function was for a temporary period, and the essential function could be performed in the near future. They also noted the inability to perform the essential function could be reasonably accommodated. That language in the complaint obviously tracks exactly what we said earlier in terms of the PWFA's definition of the term qualified employee. In the last case we're going to talk about that was filed by the EEOC, the employee was a medical assistant for a medical practice in Oklahoma. The company required medical assistants to be on their feet most of the day and did not allow them to perform their duties while sitting. They also did not guarantee that the employee could take a break. Due to some pregnancy-related medical issues, again, like swelling, pain in her feet, legs, and abdomen, the employee's doctor advised that she needed to periodically sit, take breaks to eat or to drink, and occasionally prop up her feet for a short time. Company denied her these accommodations. The employee later submitted additional doctor's notes seeking other accommodations related to her pregnancy, and all those requests were denied. Okay, so one interesting fact about this case is that the earlier requests that I just mentioned, those arose before the PWFA went into effect in June of 2023. So after the PWFA went into effect, this employee, who's very knowledgeable about the law, at least according to the complaint, reiterated her request for accommodation, and they were again denied. According to the EEOC, the employee asked the HR director if he was aware of the PWFA and the duty to accommodate pregnancy-related issues. And again, according to the EEOC, the HR director said, no, he was not aware. Perhaps he should have become educated. But anyway, after the employee had her baby, she told the company she was ready to return to work. And she asked whether she'd be allowed to take a 30-minute break to pump breast milk. The company said it could provide her a room so that she could pump, but it couldn't guarantee that she'd be provided breaks to pump. So not very helpful, frankly. Again, according to the complaint, she was told she would need to coordinate the times when she was going to pump with her supervisors and the physician that she was assigned to that day. Accordingly, the employee did not return to work because they couldn't guarantee her that she'd have breaks to pump at work, and she was fired. The EEOC sued the employer for failing to accommodate known limitations related to pregnancy, forcing her to take leave, and also for terminating her. The EEOC stated in its complaint the employee's swelling, pain, discomfort, and need to take breaks to pump were all covered by the PWFA. Again, this lawsuit illustrates the need to accommodate even those sort of minor limitations under the PWFA.
We also want to point out that in addition to the cases we've summarized, there have already been 2 published conciliation agreements with the EEOC under the PWFA. 2 Florida employers, ABC Pest Control and Sailor Men, Inc., have entered into these conciliation agreements. ABC Pest Control was accused of firing a pregnant employee after she requested a reasonable accommodation to attend monthly medical appointments for her pregnancy. And Sailor Men was accused of firing a pregnant employee because it believed she would need accommodations to perform her job duties. One interesting thing about these conciliation agreements is the requirement that the employer appoint an EEO coordinator and report complaints received to the EEOC.
Yeah, and for those of you who are listening, particularly HR professionals, you know that that's not something that you really are looking forward to, which is that when you get a complaint from an employee with regard to an accommodation or discrimination, and you have to then report that to the EEOC. So I think it is an important aspect of these conciliation agreements.
The General Counsel of the EEOC stated that as of September 12, 2024, the EEOC had received 1,869 charges from workers who claim that their employers failed to provide them with accommodations under the PWFA. Additionally, around 100 lawsuits have been filed under the PWFA by employees, and this number continues to grow.
The EEOC has not yet filed a lawsuit under the PWFA that involves a request to work from home. However, roughly 20 of the individual employee lawsuits brought under the PWFA to date involved a denial of a request to work from home. I think this is something to really pay attention to because I think employers are going to get this type of request. And it's important to understand that EEOC guidance states that working from home may be an accommodation for a pregnant worker. When, for example, the employee needs to work from home for bed rest or due to mobility impairment or the need to avoid a heightened health risk, such as from a communicable disease. So I think it's important to just keep in mind when you get a request to work from home from a pregnant employee or employee trying to get pregnant, and it's due to some related medical condition, even if the employer has policy that says, employees are not allowed to work from home, that may be something the employee needs to provide as a reasonable accommodation. All right, that's it for us for today. We know this was short, but we hope the webinar has been useful. We will continue to monitor this new law, and we will certainly expect to see more litigation, at least from individual plaintiffs, going forward. Thank you very much.